Hello everyone, a pleasant afternoon to all of you. This is group 7 and we about to tackle the lesson 9. Arrest. Arrest is ito yung pagkuha o paghuli sa isang tao sa ilalim ng kapangyarihan ng batas para siya ay managot sa paggawa ng isang krimen. And so, arrest how made o ginagawa sa pamamagitan ng aktwal na pagpili ng isang taong aarestuhin o sa pamamagitan ng kanyang pagsuko sa kapangyarihan ng umaresto sa kanya. Next, ito yung step kung paano gawin ang pag-arrest. Number 1 is ito yung dapat walang karahasan o di kinakailangang dahas ang dapat gamitin sa paggawa ng pag-aresto. Next is, sa pag-aresto, dapat sabihin sa inaaresto na siya ay huhulihin at sabihin ang rason kung bakit ito hinuhuli. At habang hinuhuli ay sabihin sa kanya ang Miranda Doctrines. Kung dala ang warrant of arrest, ipakita sa hinuhuli. Kung di naman, pwede na rin hulihin at ipakita ang warrant pagkatapos kung ito ay gusto ng taong hinuhuli or dinadakip. So next is the by virtue of warrant. The officer shall inform the person to be arrested of the cause of the arrest and of fact that a warrant has been issued for his arrest, except when the flees or forcibly before the officer has the opportunity to inform him. Next is arrest. Number 2 is arrest without warrant under exceptional circumstances as may be provided by state statute, section 5, rule 113, rule of court. So this is like the warrantless arrest that has caught in the act when the person to be arrested has been committed as actually committing or is attempting to commit an offense. Next is the warrant of arrest. Ito ay isang dokumento na pinapakita sa isang taong akusado na naglalaman ng dahilan kung bakit siya ay inaakusahan na karaniwang inihahain or pinapakita ng pulis bago ang pagdakip. Kaugnay ng warrant of arrest ay ang ebidensyang nakalap laban sa taong hinahain nito. Ito ay karaniwang hinahain para magkaroon ng malinaw na basehan sa pag-aresto sa taong nasasakdal bago siya dalhin sa kulungan upang tanggapin ang kanyang magiging hatol. Next is the essential requisites of a valid warrant of arrest. This must be issued upon probable cause. The number 1 is warrant of arrest. Arrest shall be in writing. Number 2, it shall be signed by the presiding officer of the court. Number 3, it shall bear the seal of the court. Number 4, it shall bear the name and designation of the person who is to execute it. Number 5, it must indicate the clear name and address of the accused. Number 6, it should state the offense with which those accused are charged. Number 7, it should indicate the date of the issue of the warrant of arrest. Next is the probable cause. It is the grounds that police or any reasonable person must have to arrest an individual, search a person or property. It is a specific requirements that the law enforcement officer must meet to show legitimate reason to believe that the person committed a crime. This means that police cannot just suspect a person of a crime for no reason. Next one is, what is Richard Doe or John Doe warrant? This is no specific person to be arrested, but it can be based to the testimonies of the victim or the witness. The John Doe or John or Richard Doe, it means that it is used to refer to a man whose real name is not known or cannot be relieved, for example, for legal reason. And then next, the alias warrant. This is issued when the subject fails to appear in the court for a scheduled court date before any plea has been entered or fails to respond to a citation of a person. And so, Section 3, Duty of Arresting Officer. The officer must deliver the person immediately to the nearest jail or police station to avoid situations when the officer will hold the law in his hands. And so, next section 4, Execution of Warrant. The judge gave a warrant of arrest to the head officer and he must deliver within 10 days. But if the officer failed to execute the warrant of arrest after the expiration of the period, he shall make a report to the judge who issued the warrant to state his reason. Section 5, the arrest without warrant. Ito yung parang quote, hindi parang, pero quote in the act. Example yung nasa bilibid or prison na tumakas habang siya ay nililipat sa ibang lugar. Section 6, time of making arrest. Ito rin yung araw ng pag-aaresto na pwedeng gawin sa araw at sa gabi. Ito ay walang pinipiling oras or minutes. Section 7, method of arrest by officer by virtue of warrant. Ito yung by virtue of warrant. Habang ginagawa ang pag-aresto, dapat sabihin muna sa inaaresto kung bakit ito dinadakip at sabihin din ang Miranda Doctrine para siya ay inform sa mga nangyayari. Yan, so section 7, method of arrest without warrant. Ito yung without warrant ng pag-aresto. Section 9, method of arrest by private person. Ganun din. Parang ganun din sa section 7. Yeah, pero ito yung private person. Section 10, officer may summon assistance. Ito, yung officer ay pwedeng humingin ang request assistant to perform wisely the arrest. Section 11, right of officer to break into building or enclosure. This is the right of the officer to enter to the house by virtue or without warrant.
Search and seizure. For example, if police officers suspect that a person is a possession of illegal drugs, they may obtain a warrant to search a person's house for evidence of drug possession. The officer enter the house and search for drugs, and if any are found, they are seized as evidence. The same principle applies to a car, computer, or any other property owned by the person. Section 1. Search warrant defined. For example, an officer of the local police department received a search warrant signed by a judge. The warrant commanded the officer to search the residence of Remark Dangilan for a stolen laptop computer. The search warrant identified the laptop by its serial number. The officer followed the instruction of the search warrant and found the laptop in the residence. The laptop was brought to the court as instructed. Section 2. Court where application for search warrant shall be filed. For example, if a crime was committed in a New York City, the application for search warrant should be filed with a court in New York City. This could include the state Supreme Court, the state court of appeals, or the state Supreme Courts. The court with jurisdiction to hear the application will depend on the type of crime and the location of the crime. Section 3. Personal property to be seized. For example, if a suspect is accused of embezzling funds from a company, a search warrant may be issued for the search and seizure of the suspect's personal property. The search warrant would allow law enforcement to search the suspect's home and seize and property related to the crime, such as documents, computer, or money. It could also allow then to seize any property that can occur with the money that was stolen, such as jewelry or cars. Section 4. Requisite for issuing search warrant. For example, Officers Smith and Pablo were investigating a case of drug possession and trafficking. After a months-long investigation, they were able to gather enough evidence to establish probable cause that the suspect was involved in illegal drug activity. They obtained a search warrant for a judge, which specified the address of the suspect residence, as well as the times they were allowed to seize, such as drug and money. With the search warrant in hand, the officer were able to lawfully search the home and seize the evidence, which was later used to successfully prosecute the suspect. 5. Examination of compliant record. For example, if a person was failing a compliant against a person who had stolen their wallet, the judge would need to conduct an examination of the compliant. The judge would ask questioning in writing and under oath to the compliant and any witnesses they may have. The answer to those questions, as well as any affidavits they present, will be attached to the record. This process is done to ensure that all of the information provided is accurate and can be used to make an informed decision. Section 6. Issuance and form of search warrant. For example, if a police officer wants to search a suspect's home for evidence of a crime, the officer must present an affidavit to a judge that provides a detailed account of the facts and circumstances that justifying the search. If the judge is satisfied that the facts are sufficient to warrant a search, the judge will issue a search warrant in the form prescribable to the rules. The search warrant will then authorize the police officer to search the suspect's home for evidence of the crime. Section 7. Right to break door or window to effect warrant. For example, a police officer has a warrant to search a house. When they arrive at the house, they knock on the door and announce their purpose and authority. However, the people inside the house refuse to let them in. In this case, the police officer has the right to break open the door or window of the house in order to execute the warrant and search the premise. Section 8. Search of house, room, or premise to be made in presence of two witnesses. For example, Pablo is a police officer and needs to search a suspect's house for evidence relating to a crime. According to Section 8, he cannot search the house unless he has the presence of two witnesses. John goes to the suspect's house and finds that the occupant is not present. He then finds two witnesses of sufficient age and discretion in the same locality who agree to be present for the search. John then proceeds the search and house with the two witnesses present.
Section 9. Time of making search. The warrant must be direct if served in daytime, unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of day or night. Dito is dapat direktang serve ang warrant in the daytime. Maliban na lang kung may written statement that confirmed by an oath or affirmation asserts that the property is on the person or in the place ordered to be searched, in which case it will be served any time of day and night. So, if there are no written statement that confirmed by an oath or affirmation, the time of making search is daytime only. But if there is a written statement that confirmed by an oath or affirmation, then the time of making search will be any time of day and night. Section 10. The validity of search warrant. Search warrant shall be valid for 10 days from its date. Thereafter, it shall be void. Dito is ang search warrant ay may visa or validity lamang ng 10 araw at kung lumagpas ng 10 araw ay mawawalan na ito ng visa. Section 11. Receipt for the property says, the officer seizing property under the warrant must give a detailed receipt for the same to lawful occupant of the premises in whose presence the search and seizure were made, or the absence of such occupant must, in the presence of at least 2 witnesses of the sufficient age and direction residing in the same locality, leave the receipt in the place in which he found the seized property. And dito is the officer seizing property under warrant must give a detailed receipt to the lawful occupant of the premises in whose presence search and seizure were made. Then, if wala yung may-ari or yung nakatira, is dapat mayroong at least 2 magwi-witness with sufficient age at dapat nakatira din sa parehong lugar. And dapat mag-iwan ng receipt sa lugar kung saan niya natagpuan ang masamsam na ari-arian. Section 12. Delivery of property, inventory thereof to court, return, and proceeding thereof. The officer must forthwith deliver the property, says the judge, who issued the warrant together with a true inventory thereof duly verified under oath. 10 days after issuance of the search warrant, his issuing judge shall certain of return has been made. If no one shall summon the person whom warrant was issued or require him to explain why no return was made. If the return has been made, if the judge shall ascertain whether Section 11, this rule, has been complained with, shall require that the property says be delivered to him. The judge shall be to it at subsection thereof has been complied with. C. The return on search warrant shall be filled and kept the custodian of the logbook on search warrants, who shall enter therein the date of return and result of the other actions of the judge. A violation of this section shall constitute contempt of court. Section 13. Search incident to lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used to constitute proof in the omission of an offense without search warrant. Dito ay kung isa kang tao na inaresto ng legal o legally arrested ay maaari kanilang kapkapan o hanapan ng mga mapanganib na armas o anumang bagay na magpapatunay na ikaw ay nagkasala with the commission of an offense without search warrant. Motion 14. Motion to quash search warrant or to suppress evidence where to find. A motion to quash search warrant and or suppress evidence obtained thereby may be filed in and act upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued by search warrant. However, if such court failed to resolve the motion and a criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. This is motion was a search warrant to suppress an evidence na nakuha. Ito ay maaaring isampa at aksyonan lamang ng korte if the action is instituted. At kung walang criminal na action ang sinagawa, ang motion ay maaaring ihain at lutasin ng korte na naglabas ng search warrant. Gayunpaman, kung nabigo ang naturang korte na lutasin ang motion, ay maaari itong isampa sa mas mataas na hukuman.